All right, welcome. Welcome to the Faculty and Alumni Group series. Today we have Breanna Vollmers here with us. She is going to do a presentation on managing export compliance in a global marketplace. It's my pleasure to introduce Breanna. Not only is she a friend and supporter of the law school, she participates in our Alumni Association Board of Directors. She's on the upcoming reunion committee. She attends events and mentors our students, and we're happy to have her as one of our alums. I'm also happy to call her one of my close friends. She and I graduated from law school together in 2005 and have remained friends since and are planning our 10-year reunion right now. Now, on a personal note, I'll tell you that she's a really good softball player, so if you need a ring, she's your girl. Following graduation in law school, Breanna worked under the executive director for the Oklahoma Department of Commerce. She then served as general counsel for IPS Oklahoma Management. After that, she served for 4 years as an assistant district attorney here in Tulsa County, and she has been with NORDAM for 4 years as the manager of global trade compliance. And without further ado, I'm going to let Breanna take over.
All right, thank you all for coming out on this lovely winter day that we have right now. At least we're a little bit ahead of the weather. And thank you also for coming to what people consider a less than riveting topic of export compliance, but luckily I love doing it, and it is what I get to do for a living every day. I hope that you have some of the handouts that are outside just as we kind of go through the slides. What my purpose is here today is to help kind of show what are the export regulations around you. I'm going to focus on why we need to care. Why do business owners, why do attorneys need to care about export compliance? Why does the government control exports? What are exports? I mean, in its most basic form, you need to understand what is an export to understand if the regulations even apply to you or to the situation that your clients are facing. Then look at the government regulations, and finally the aspect of violations. What happens if the laws are broken, and some examples of some of the sets of sanctions. So first off, exporting in the U.S. The U.S. Commercial Service says that small and medium businesses account for 98% of all U.S. exports. So most likely that can be a small business that you're working for. If you're an in-house counsel, you need to pay attention to this. But in addition, small and medium business owners themselves need to pay attention to it if they come to you and ask questions. In 2011, U.S. export of goods and services from the U.S. was a $2.1 trillion business. It's enormous. But yet, despite that, only 1% of U.S. companies export, and only 62% of exporters surveyed in 2009 had a robust compliance program. What does that mean? There's a huge exposure for exporters in the U.S. right now. Why do you need to be familiar with export regulations? It's the same as breaking the law with the speed limit. If you walk up to an officer and they come up to you and stop you in a speed zone and go, "Did you know you were going 75 and a 55? The excuse of, "Nope, I had no idea," isn't going to get you anywhere. The same thing attorneys warn all clients. Ignorance of the law is no excuse. It's not going to get you out of a fine. I want to explain first and focus on two sets of export regulations in this presentation. First is the Export Administration Regulations, known as the EAR, and the second is known as the ITAR, the International Traffic in Arms Regulations. Some of you might have heard of the ITAR before. This is generally the regulations around military exports. It became a little less clear-cut last year, but we'll get to that. President Obama implemented some changes in export regulations that make things a little bit more complicated. But you need to just understand that there's two basic sets of regulations, two sets of lists. There is also a third list that I'm not going to look at today called the Nuclear Regulatory Commission Controls. There are special regulations around goods and items that can be used in producing nuclear, both energy and nuclear weapons. Very specialized. If you're doing anything that can be used in multitasking for those, I highly recommend you look at the Department of Energy and Department of Nuclear Regulatory Commission. So, but first off, most basic form. To even understand if those regulations apply, you need to understand what's an export. An export is literally the transfer of any item, either commodity, technology, or software, to a foreign destination. If it's leaving U.S. borders, it doesn't matter if it's going to your own company's subsidiary. There is no carve-out in the regulations for it. It's an export unless it's going to your own company. An export is an export. If it's leaving U.S. borders, it's an export. Or if it's transferred to a foreign person within the U.S., it can also be an export. It's a fun carve-out. The U.S. regulations are also some fun extraterritorial application because U.S. laws cover an item once it leaves U.S. borders, including any re-export. For instance, if we're in the U.S. here, my widget in Tulsa gets sold to a company in London. It's a U.S. widget, right? And the London company decides to resell it on to a company in Sydney. U.S. export controls will follow that widget on its export from London to Sydney. And if the party in Sydney never should have received it without an export license, the company in London can get in trouble. The U.S. government also has a set of regulations where they can control your conversations. They can control site tours. It's called a deemed export. So the U.S. government doesn't just focus on the transfer of items, physical items, in export controls. They also can want to know who is getting technical know-how. So think about how we as businesses operate today. You have conference calls with shared desktops. You have FTP sites, right? You have a location where you have someone on a site tour. You're bringing in foreign customers to tour your facility. Think about that. If I happen to work for NORDAM, an aircraft manufacturing company, guess what? Aerospace is always has foreign customers coming to visit. When you take them on a site tour of the facility, if you're walking up to a part that's being manufactured, do you think someone can gain know-how about how that's being made just by watching the mechanic standing there? Absolutely. And export controls then apply. If that person is a foreign person, again, so let's say the visitor is from New Zealand and they're walking around the facility, hopefully my group has been checked with beforehand to go, we have visitors from New Zealand. What can and can they not see in the facility? Because we don't want to get in trouble for having an unauthorized export of technology. It's a very hard thing to wrap your head around until you actually realize, that's right, I can gain know-how. I can walk up to this podium, look at this computer. Maybe as its final form, I can't gain know-how, but if you take it off and I can see the inner workings of it, just by standing here looking at it, I can probably figure out a lot about how it's made. So gaining that know-how, that piece of the puzzle, is controlled for export purposes. There are four main categories of exports. First one I want to talk about is commodities. This one's easy to think about. The physical item you're sending is controlled for exports. Some of the examples I chose on this one are because they're literally higher levels of control. People get in trouble often because they don't realize that they need to know who they're sending these items to. Rifle scopes, very heavily controlled. Taser guns, believe it or not, they're controlled. That may be hard to realize, but they're controlled for what's known as crime control. Valves are actually a very high level of controls around valves that are used in the oil fields because we have lots of sanctions against countries related to oil field technology. In addition, many of the valves can have application in nuclear reactors and nuclear energy section. Believe it or not, fruit can be very highly controlled, and in addition to meat. There are lots of controls around importing those things. Why? Certain governments have restrictions on genetically modified organisms being imported. That if the fruit, the meat, was genetically modified at some point, it can't enter certain countries. It can be banned. Nail polish I have on there because of a fun case a few years ago where a company got fined severely because they sent nail polish to Iran. You can't send anything to Iran. And they sent nail polish via a company, I believe, in the UAE. They knew it was going to be sent on to Iran. They got fined. It doesn't matter if it's nail polish or if it's taser guns. The same set of regulations control them. Also technology. So you have the items themselves. The technology of how to make them, how they're repaired, is also heavily controlled. And it makes sense. You don't want people to have the item. You also probably don't want them to have the technology that makes that item. Services. This third category, again, is one that people often don't think about. Controls around, I talked about the site tour where if you can walk up and watch a mechanic making a part, that's controlled. Well, think about the mechanic training someone how to make that part. If they're sent to a foreign country to train individuals, if you're a consultant and you travel to a foreign country, if you are, again, imparting technical know-how, imparting that training, that's controlled for export purposes. You need to know who you're talking with and what country they're from or what country you're traveling to. And finally, software or source code. It's easy to think about the computer itself being shipped, but we rarely think about what software is installed on it. Encryption software is very heavily controlled. In addition, the source code, what runs an autoclave, what runs a CNC machine. It's specific programming that says this machine is going to do this specific action. That is equally controlled under export regulations. So you've got the 4 different categories. Now I want to focus first on the EAR. So this is that first set of regulations I talked about, around mainly commercial items. The Export Administration Regulation controls items that are of U.S. origin, wherever they're located. In addition, if the foreign-made item contains U.S. origin items, for example, the Boeing 787, okay, not all of it is made in the U.S. Let's say that Boeing opens a plant in Canada. If a certain percentage of that item is made of U.S. origin parts, U.S. laws will apply to that 787 no matter where it's manufactured. In addition, if the item is made outside the U.S. but with U.S. origin technology. So, for example, a lot of aerospace manufacturing companies, have plants in Mexico. There's a large number of manufacturing facilities in Mexico. Okay, for instance, Cessna has a plant there. They're making parts for, let's say, the Cessna Citation jet. If that part is made using drawings that were originated at Cessna in Wichita, that part is entirely controlled under U.S. laws. It doesn't matter that it's made in Mexico by Mexican nationals. The fact is it was made with U.S. technology, the drawings originating in Wichita, so U.S. laws apply to that part. What's the reasoning behind that? The U.S. government wants to maintain its maximum level of control as possible. They don't want companies going outside the U.S. to manufacture items simply to try and escape U.S. export controls. In this example, Mexico doesn't have the same embargoes that the U.S. does with Cuba. You can't manufacture outside the U.S. just to try and get around U.S. export controls. Because if you do, you can face violations, penalties, criminal and civil penalties. The EAR is interesting in that it does have 2 different sets of violation categories. You have a willful violation and a knowing violation. A willful is pretty self-explanatory. The individual, the company, they willfully disregarded export control laws. They knew that there was a violation occurring. There's an instance right now where a company out in California is facing, charges, criminal and civil charges, because of willful violations. They were an ATV company, manufactured ATV parts, not manufactured, sold them. Well, U.S. Customs noticed that on their eBay site they were selling rifle scopes, not ATV parts, but they also noticed that every export that they sent and every shipping paperwork only listed ATV parts being sold. They willfully misled customs. They lied on their customs declarations on purpose because rifle scopes require a license to be shipped to many countries, including those that they were shipping them to. You get in that special category of willful, you can face up to $1 million fines as a corporation, or 5 times the value of the export. As an individual, you can face criminal fines. If you are the shipping clerk who changed it from rifle scopes to, say, list ATV parts, on every shipping declaration, there is a signature line on the bottom where the clerk declares, I hereby verify that the information on this invoice or this shipping declaration is accurate and correct. The person who signs those documents can be individually charged. The person who induces someone to sign those documents or provides false information to get those documents that way can be individually charged. A knowing violation, again, you've got a little bit less of a burden on that. You really should have known better. You should have known that export controls applied to you in this instance. A lot of people in my company, we train every individual that comes to the door on export controls. Every new hire gets that training. So we say, congratulations, you signed up for training, you've been employed here, you can now be charged with a knowing violation. It gets a good reaction at the new stakeholder training. But that from a knowing violation of, I should have known to ask questions, you could have a criminal fine of up to $50,000 or 5 years in prison per violation, and a civil fine of up to $11,000 per violation. Or if the item is controlled for a higher level of controls known as national security, you can up the ante to a $120,000 fine per violation. And again, remember, we love federal prosecutors. I used to be a prosecutor. A prosecutor will label and try to charge you with every potential crime that they can. So you are not going to be charged with a single violation of the EAR. You may also potentially face violations of filing false tax returns, conspiracy to violate. You know, there was one gentleman who faced 15 different criminal charges, and only 2 of them are related to export controls. So, and also with violations of export controls, you can face administrative penalties as well. It can be a 3-fold penalty for the same act. You can have seizure of the goods that were illegally exported. And if any profits or proceeds from that illegal export. And from a criminal side, you can face up to 3 times a fine for any illegal proceeds made from the export. You can also face, as an individual and as a company, an export ban. Become what's known as a debarred party or a denied party. You as an individual or your client can be barred from exporting. And if it's an individual, any employer would take on their ban who employed them. So it can make it extremely difficult for any individual. The case I just talked about with the ATV company out of California, there are 3 individuals, I believe right now, who, while pending charges, have an export ban applied to them. They haven't been convicted of anything. They haven't admitted to anything, and they've already got an administrative ban applied to them. In fact, on their company's website, it now clearly states that they cannot ship outside the U.S. And I did want to point out that there is now a new case that came down from the 3rd Circuit. And I apologize, I forgot to put the citation, Federal 3rd on there. U.S. v. Trek Leather. U.S. v. Trek Leather applied or reinforced the fact that anyone who is a person who is involved with illegal import or unauthorized import in this instance can be criminally or civilly charged, can face civil liability. The case specifically said you don't need to pierce the corporate veil in order to hold someone who personally acts and is involved in this illegal import. In this instance, the gentleman was a sole owner and proprietor of a company who made suits. So he actually was responsible for the import documentation. He specifically undervalued items on purpose to pay less custom duties. The problem with him was he had already been found by customs to have done this once before. So he specifically knew he should have put the right value down, specifically didn't. He didn't file the paperwork with customs, but they said that the court specifically found that he gave them the documents they relied on. He prepared the invoices. and he should have known better. They found him guilty of gross negligence and a fine of $540,000 civilly. That's not counting any criminal charges. That's not counting any potential penalties on the other side. That was for imports. Okay, and this case has caused a huge stir in the export community because they can apply the same theory that you are a person, an individual. You don't have to be the importer of record. You don't have to be the exporter of record. You don't have to be the one who filed and signed the documents. You just have to be responsible for the documents that were filed, for the act taking place. So small and medium businesses, all of those entities I talked about at the beginning, need to be concerned with this case. Because it's no longer about piercing the corporate veil. It's about, were you responsible? If you were, you can be held responsible. Two specific cases just to talk about. Remember how I mentioned the deemed export. This is the sharing of know-how. A company called Invitech was entered what's known as a voluntary consent agreement. They voluntarily disclosed to the BIS, the Department of Commerce, that they violated the EAR. They had a Russian employee, and they granted this employee access to drawings, blueprints for parts, identification numbers, development, production plans that were subject to requiring an export license to be exported to Russia. This was for hard disk drive manufacturing. Okay, just manufacturing. Nothing controlling military items, doesn't matter. The government cares about more than just military items. The Russian national was required to have a license. Okay, so they voluntarily disclosed to the U.S. government, we screwed up. We should have had a license to have this guy work for us and have access to this data. The government said, thank you for telling us. You now have a $115,000 fine. Please don't do it again. B&H Photo. Again, December 2014, they exported 50 optical sighting devices. They exported all around the world. These are, again, gun sights. All around the world. Their shipments only valued $23,000. Again, they disclosed, they told the government, whoopsies, we screwed up, please be nice. And the government said, thank you, come again, $275,000 payable in cash or cashier's check within 30 days of the order. The one thing I did want to point out, I forgot about Invitech, is that immigration law and export control law are completely different. A work visa is not the same as a permanent resident card. This is extremely important to remember. A work visa does not grant an individual access to data the same way as a U.S. citizen. President Obama's plan to fast-track immigration will not affect how export controls treat illegal immigrants. They are still treated the same as an immigrant, as a citizen of their home country. Okay, this is very important for individuals to understand, for your HR departments to understand, because a work visa does not make you a U.S. citizen. It makes you allowed to work in the U.S. The export control regulations don't care. That just means that you just committed the violation in the U.S. instead of in Russia. So again, very important, make sure that HR departments that you work with understand that. Because there's also this new regulation. Okay, remember how I said it used to be black and white, there was ITAR was military, EAR was commercial. Well, in 2013, the export control reform began. And this is the gradual shifting of items from the ITAR to the EAR, creating what's known as a new category called the 600 series. What this means is, this is a quote from the DDTC, which regulates the military side for the ITAR. President's Export Control Reform Initiative designed to better protect America's most sensitive defense technologies while reducing unnecessary restrictions on export of less sensitive items. That makes as much sense to you as it does to me. What it means in reality is that things are very, very confusing. What used to be black and white is no longer. You now have to determine, well, is that item specially designed for a military use? What was its original purpose? What is its use now? Is it part of the specially controlled, most sensitive technologies, or is it less sensitive? For instance, the F-16 is no longer an ITAR-controlled plane. The items that went on it, everything used to be very black and white. If it's for an F-16, it's a fighter jet, right? It's got to be military, ITAR-controlled. Not anymore. The jet as a whole still is very controlled, but the parts that make it up now have shifted over into the 600 series. The ones that are the most sensitive are now the F-22, the F-35, the B-2 stealth bomber. Okay, we still have so essentially the ongoing new developing technologies and the one stealth technology that we still really want to protect. But the A-10 Warthog, your F-16, pretty much any cargo helicopter, those have all, and any cargo plane, have all shifted into this 600 series. So if you have a customer that deals with military items, this ECR, this export control reform, is extremely important to them. And it is extremely confusing, and it's worthwhile to hire consultants who know what they're talking about. Because this, again, you don't want to fall back into this category of fines and penalties. We actually had an individual talk to my group this week, and one of our stakeholders, and he said, well, surely, the government's going to give you a grace period where it's okay if you screw up. No, the government doesn't work well with grace periods. It's pretty much, this is the law that's in place, you should have followed it. That's why they have that special category of knowing. You should have known better. I did just want to put this up. These are all the different categories that are going through changes based on this ECR. It's essentially every part of the ITAR has something that's being rewritten on it. Again, if you have a client where it falls under the ITAR, and you really need to figure this out. Because the regulation of military items under the ITAR is still very strict. Defense article, any item designed for, designated for what's known as the USML, the United States Munitions List, is included, including technical data stored in a physical form. What does that mean? If you have a printing or a print that you've made into a Mylar, the physical copy is controlled. If you have it saved on a computer disk or on a jump drive, it's controlled, that physical form of it. And this is the interesting thing with the ITAR. They control defense services. So let's say that you have your company that you're advising has F-16 program, or excuse me, the F-18 program. There are F-18s around the world. I believe Israel has some. Okay, great. Well, I've got to send some contractors to Israel to go work on their plane. We've got a warranty part. What do? Well, guess what? We have to go to the department and get a special license called a Technical Assistance Agreement that allows my guys to go to Israel to advise on how to fix that F-18. Giving that technical know-how, providing that defense service is very highly controlled by the Department of State. And they care, again, a lot about who are we training how to use those defense items. How are we training them? And one thing to remember actually about ITAR and EAR is who owns the plane it's going on doesn't mean what set of regulations apply to it. Or who owns the ground vehicle, or who owns the gun it's going on. Okay, the end owner of the item doesn't decide whether it's military or commercial. It goes back to the original design. Was it originally designed to go on an F-18? Was it originally designed to use on an M1 Abrams tank? Okay, so again, ITAR and EAR, very confusing, very tricky. This is why it's very important to have a good compliance program who can delve into this, who can see the nuances and make sure that your company, your clients are well advised and well informed. Because ITAR doesn't have the oopsie category. ITAR just has up to $1 million fine and 10 years in prison, or $500,000 on the civil side. And they have the same export bans. But the ITAR and the EAR do actually kind of speak to each other as far as penalties go, because once you become criminally convicted on the ITAR side, EAR will institute a ban as well. And if you're criminally convicted on the EAR side, ITAR will follow and give you the same type of ban. So you're not going to be banned just from exporting military items or banned from exporting commercial items. You're going to be banned from export. And if you violate the ITAR and have a criminal conviction, by statute, you are a debarred party for a minimum of 3 years. And you have to actually apply to get your export privileges reinstated after that period expires. It's not automatic. You don't just get to start exporting again someday. You have to ask the Department of State, pretty please, can I start exporting again? I promise to do better this time. And one of the key companies that I deal with is Pratt Whitney Canada. Pratt Whitney Canada has the unique distinction of being a convicted felon as a company. They were convicted of violating the ITAR in 2012. United Technologies, specifically their subsidiaries, Pratt Whitney Canada, Pratt Whitney US, Sikorsky, Hamilton Sunstrad, and there were 3 others, I believe. It was 7 subsidiaries were part of this enormous consent agreement. Because Pratt Whitney Canada, at the heart of it, decided to collaborate with the Chinese government on developing a helicopter. Back in 2002, I believe it started. The problem is that helicopter was military from the start, and Pratt Whitney Canada tried to hide that and said it was commercial. If something is designed as military from the start, special regulations apply to it. Hamilton Sunstrad supplied the technology that ran the engine that Pratt Whitney sold to the Chinese. They sent engineers to China to develop this. It is still in development, actually, is the Z-10 military attack helicopter. I believe it's similar to the Apache. It's actually a tandem seating helicopter. It's an attack helicopter. There's no way there was ever a commercial use for this helicopter. Well, they had exported 12 engines to China and told the Canadian government, oh yeah, these are commercial, don't worry about it. They don't need a license. And eventually, I want to say that they got caught because somebody asked the right questions of some engineers who were coming back. And they realized that these engineers had ITAR-controlled data, and they said, why do you have ITAR-controlled data? And then it made it into the news that Pratt Whitney Canada was helping to develop this Chinese attack helicopter, and they said, whoa, time out, what? And that's when customs got real included. So if it hadn't made the news, they still would have been fine. However, they weren't. And once the U.S. Department of State started to investigate, remember, they're not just going to look for the violations with those attack helicopters. They're going to look at Pratt Whitney's entire program and United Technologies. And they found enormous problems, specifically that their internal networks had no controls on them at all. Again, you're dealing with an international company, and a company who had lots of foreign nationals on site in Canada. They specifically found 260,000 employees from 90 countries had access to controlled technical data. I believe that one of the phrases were the violations demonstrated a systemic corporate-wide failure to maintain effective ITAR controls. One part of the charging document said that there were so many violations they could not be counted. That's bad. That enters the special category of uh-oh. United Technologies was fined $55 million civilly. $20 million of that fine was essentially suspended, and United Technologies has to spend that $20 million internally to remediate their export control programs. $35 million was payable in $7 million annual installments, again by cashier's check or money transfer. That's a $7 million cash off their bottom line. Again, United Technologies is an enormous company, but still, that's hard to swallow. But they also faced $13.8 million in criminal fines. Then you get to Pratt Whitney's felony case. They were fined $6.9 million criminally for the willful violations. That had to do with I believe $1.2 million or actually profits that they made off of those helicopter engines that were exported, and then treble the fines of the profit they made. So that's where the 6.9 comes in. They also, again, statutory debarment, banned for 3 years. If they're nice and they're good, they can ask in June to become a regular party again, where we can ask for licenses to export to Pratt, Whitney, Canada. So what do you need to tell your, what do people need to do? How can they avoid these violations? The thing is, you got to know who you're doing business with. That's the main thing at the end of the day. If you are a customer, you got to know who you're doing business with, and you should be looking for red flags. Your clients need to look for red flags. They can't just say, well, they've got money, why should I care? Just accepting a purchase order because it clears your financing side doesn't mean you should accept it. Looking for individuals that are, or entities that are willing to pay cash in advance, and only cash, untraceable. If they're looking for abnormal quantities. If it doesn't fit their business structure, right? If you've got an ice cream shop and they're ordering weapons sights, you better be checking a red flag on that. Why? Why does Hal's Ice Cream need weapon sights? That's great. Does Al have a side business? Right? If the shipment involves, it should involve installation. Okay, if you, for instance, you have autoclave ovens, right? You have these enormous things. They weigh tons upon tons, but they're also extremely complex. They need proper setup. And if the buyer says, oh, no, we don't need setup, we don't need installation, just send me the item. You don't? Why? There's probably a reason why. They're probably transshipping it on to somewhere else where they can't get it legally. And if it is an intermediary, and it's very clear that the business that is purchasing it is an intermediary, they are a middleman. You know that this is a shop front in a strip mall. What are you doing with your item? If that shop front really should never be buying something, you know they're sending it on, you need to be asking the next question of, okay, who is going to be the end user of this? Because these are the parties that you need to know. Who's paying the bill? Who's ultimately using it in the end? The ultimate consignee. The intermediate consignee. You need to know if it's FedEx, if it's DHL, if it's Ralph Shipping. This is very important in foreign countries because there are a number of entities that are actually denied as freight forwarders. Kuhn and Nagel for a period of time was a denied party because they mismanaged U.S. Army shipments, military shipments. So they were denied party for ITAR shipments. They couldn't be involved. So even worldwide entities, you need to know who's involved, and especially if you have to go to the U.S. government and apply for a license, you actually need to list all of these parties on your license application. And finally, there is some help of how can your customer figure out who can you do business with. The U.S. government actually this year came out with what's known as a consolidated screening list. It's on export.gov. And it's because the U.S. government, as you might know, the branches don't always work well together. The Department of Commerce has their own denied parties list. They also have what's known as an unverified end users list. The Department of Commerce, for shipments that leave the country under license, will try to verify that the receiving party actually is the receiving party. They will go to foreign locations and knock on doors and try to get information. And unsurprisingly, certain companies don't want to talk to the U.S. government. So they can be placed on what's known as this unverified entities list. Doesn't mean necessarily that a license will be denied to them in the future, but it makes it questionable. So this consolidated screening list does actually combine all of the government entity lists and is a nice centralized screening database. There are also numerous companies that your clients can hire to actually have software that screens all of these entities, including foreign screening parties, foreign lists such as the Interpol list, the U.S. Marshals Most Wanted list. They also can screen Japan and the UK and the EU all have their own sanctions lists. So there's numerous softwares that actually do global screening that are very valuable and worth the investment. So I've talked about one small aspect of export trade controls, but the fact is there are numerous trade controls that an export compliance or a global trade compliance program should be looking at. I mentioned briefly with Trek, the USV Trek leather, importing. Importing is equally important. You're making declarations to the U.S. government. You're making declarations to the Customs and Border Patrol. And if you make the improper ones, your stuff is held up at the border. You don't get the shipment. They can seize the shipment and any profits from it. Knowing which tariff or classification code to give is very important. AES filings is automated export system. Every export that is made outside the U.S., I believe over a value of $2,500, needs to be filed with AES. Most customs brokers do it. Most people, when you ship via FedEx, you don't even realize that an AES filing is being made on your behalf, because you actually delegate that authority to the freight forwarder. However, it's very important to make sure that the right declarations are being made. NAFTA certificates of origin. If you're doing business within the U.S., within Canada, you want to make sure that you're exempt from taxes. You don't want to pay tariffs if you don't have to. Knowing where the NAFTA certificate of origin comes into play, and the country of origin of any item is also very important from the tariff declaration side. License applications, how to apply for an export license, how to get one, how to manage one, all very important. And if you're dealing with, if you're a manufacturer or a broker and you deal in items controlled by the ITAR, you may have to be what's known as registered with the DDTC. It's a registration process. Takes about $2,500 to become registered. You have annual registration updating requirements. Why? The U.S. government cares very deeply about who is making and brokering munitions, anything controlled on the munitions list. And failure to be registered can be very expensive, can be very detrimental to your business. Again, understanding all of these things is huge. Do most companies understand these? Not really. I mean, again, I work with companies every day. I'll call our vendors and go, hey, this widget you made for us, what's its ECCN? What's the export control codes for it? And most of the time I get, huh? I'll say, well, just send me to your shipping department. Your shipping department might know. But it shouldn't just be relying upon the shipping department. There should be an actual compliance program in place that makes sure that companies and individuals are following the law. Because again, if you get into that personal, criminal, and civil liability, it can be beyond detrimental to your business and to you individually and your personal well-being. So with that, here's some helpful sites. If you have any questions, please feel free to contact me. I didn't put my information on there. I do have some business cards. I'll be happy to talk to anybody because, as you can tell, I'm a geek about this. I love export control stuff. But again, it is very important. If you as an individual ever are working with clients who this situation comes up, make the recommendation to contact somebody who knows what they're talking about, because it is very important. Thank you all for your attention. I appreciate it. Have any questions? Yes, sir.
Oh, yeah. So are internet companies responsible for then selling their products to a plain old buyer on the internet?
Yes. If a company is posting on the internet, similar on eBay, they need to know who they're selling to.
Okay.
It needs to look at the shipping address, and mind you, once you accept a purchase order, you still can reject it by knowing when you do your due diligence later down the line and find out, wait, we need to get a license. I mean, most of the time, it's not that a transaction can't happen, it's that it needs a license from the appropriate government agency to occur. And the license does not take, there's no fee to apply for a license. That's the one thing. The government agency, no government agency charges a fee to apply for a license. However, like I said with the DDTC, you may have to be registered first in order to apply for a license if it's on the military side. But it's important that you just obtain the right license and get the right permissions. But yes, that's an excellent point, is whether it's an internet company or someone selling their stuff on eBay, it's important to know who you're selling to and where you're sending it. Any other questions? All right, thank you all very much. Appreciate your attention.